We've all heard the big promise, right? Form an LLC and boom, this legal shield pops up to protect your personal stuff if the business gets into trouble. Your house, your car, all your savings, supposedly safe and sound. But here's the thing. That shield, it's really designed to protect you from business debts. So what happens when the trouble comes from the other direction?
What if you get into personal trouble? A bad car accident, some unexpected lawsuit, maybe even a messy divorce. Is that LLC Shield still the fortress you think it is? Is it protecting the business you've poured your heart and soul into? Or is it actually more like a cheap picket fence? Well, the answer is not nearly as simple as you think, and it all comes down to a crucial little detail that most business owners completely miss.
Okay, so let's say a creditor gets a judgment against you personally. They can't just kick down the door to your LLC and start selling off your company computers and equipment. That's not how it works. The law gives them one very specific and honestly a surprisingly limited key to get at your business assets, and that key is called a charging order. A charging order is a really fascinating legal tool. It's designed to do two things at once, to strike this very delicate balance. On one hand, it helps the creditor get paid from your business profits. But on the other hand, it protects the business itself from being totally dismantled just to pay off your personal debt. It really respects the idea that the company is its own separate thing. Think of your LLC like it's a locked treasure chest. Now, a creditor who has a charging order, they can't force that chest open. They can't come in and start making management decisions. They can't force you to sell assets. They can't vote on anything. All they can do is stand there with a bucket, basically just hoping to catch any of the treasure, the profits, that you decide to pay out to yourself. And here's the kicker. If you don't make any distributions, their bucket stays completely empty. So why does this whole limitation even exist? Well, it all comes down to a really simple, old-school idea, the pick your partner principle. The law basically says you shouldn't be forced into business with your partner's creditor. It's there to protect the other members of the LLC from some stranger suddenly showing up in the boardroom with a claim. But that begs a really important question. What happens if there are no other partners to protect? And this right here brings us to the central paradox of the whole thing. What happens in a single-member LLC where you are the one and only owner? I mean, who exactly is the law trying to protect in that situation? This is the exact point where that ironclad shield starts to look pretty darn vulnerable.
With this single-member LLC, it's just you, one owner. The entire pick your partner idea, the whole foundation for why the charging order is so limited, it suddenly has nobody to protect. The logic just kind of falls apart.
This legal quote really gets right to the heart of it. It sounds complicated, but all it's saying is that when you look for the group of other members in a single-owner company, well, that group is empty. It doesn't exist. And if that's the case, the whole protective reason for the rule just seems to evaporate. So this is the exact question that courts have had to wrestle with. If the whole justification for the rule is gone, should the rule itself stick around? This question led to a landmark case that, frankly, every single-member LLC owner absolutely needs to know about. The case was Olmstead versus the Federal Trade Commission, and it went all the way up to the Florida Supreme Court. It stared the single-owner paradox right in the face, and the decision it came to sent absolute shockwaves through the world of asset protection. So the facts were pretty straightforward. The owners of several of these single-member LLCs owed a huge personal debt, over $10 million. A lower court told them to hand over their entire ownership stake in the companies, but they appealed, arguing that, under Florida law, the creditor's only option was a charging order. They were essentially saying, nope, you can't take our companies. You just have to sit and wait for us to decide to pay ourselves. The question for the court was simple, but it was also incredibly profound. For a single-member LLC, is that charging order the only tool a creditor has in their toolbox? Or can they go a step further and just seize the entire business? And you won't believe this, but the court's entire decision came down to a single word. See, when they looked at Florida's law for partnerships, it said very clearly that the charging order was the exclusive remedy. But, and this is a huge but, when they looked at the law for LLCs, that word, exclusive, was just missing. It just said a charging order was a remedy, not the only remedy. And right there, that was the whole ballgame. The court ruled that because the legislature didn't bother to use the word exclusive, they must not have intended for the charging order to be the only option. So for single-member LLCs, where there are no other partners to protect, creditors could use other tools, including taking over the entire ownership interest. The shield was completely shattered. So you might be thinking, okay, that's one Florida case. Why does this matter to me? Well, it matters because that single word, exclusive, has now become the critical dividing line in LLC law all across the United States. The difference really comes down to this. If your business is set up in a state where the law specifically calls the charging order the exclusive remedy, your shield is strong. A personal creditor can't do much more than just wait for profits. But if you're in a state without that magic word, your entire business could potentially be seized to pay a personal debt. The difference is quite literally night and day. So the big takeaway here is really clear, and it's urgent. The protection you think your LLC gives you is not a one-size-fits-all guarantee. Its strength, especially against your personal creditors, hinges entirely on the very specific wording of your state's law. This is absolutely not something you can just assume is fine. You have to know what your state's statute actually says. And that really leaves us with one final thought. We spend so much time and energy trying to protect our personal lives from our business liabilities. But maybe, just maybe, the more important question is the one we almost never ask. Is your business's legal shield strong enough to protect it from your own life? The answer is hiding in plain sight, written in your state's law books. It's probably worth looking up.